From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court takes up a case on Section 230, the legal immunity for internet platforms, but the justices seem uncomfortable with both the positions advanced by the parties. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. Welcome to you both. The case on Tuesday morning at the Supreme Court was Gonzalez v. Google. It is brought by the family and the state of a 23-year-old American student who was killed in a 2015 ISIS attack. And the argument is that Google, which owns YouTube, the video website, aided and abetted ISIS because its algorithms recommended ISIS videos to users. And according to them, that recommendation by the algorithms is not protected by Section 230, this platform immunity that is in U.S. law. And the justices seem to be trying to grapple with a way out of this conundrum. Let's start with Justice Elena Kagan.
Every other industry has to internalize the costs of its conduct. Why is it that the tech industry gets a pass? A little bit unclear. On the other hand, we're a court. We really don't know about these things. These are not like the 9 greatest experts on the internet. And I don't have to accept all Ms. Blatt's "the sky is falling" stuff to accept something about, boy, there is a lot of uncertainty about going the way you would have us go.
And let's hear from a justice on the other side of the aisle, proverbially speaking. This is Justice Brett Kavanaugh.
Isn't it better to keep it the way it is for us and Congress, to put the burden on Congress to change that, and they can consider the implications and make these predictive judgments? You're asking us right now to make a very precise predictive judgment that, don't worry about, it's really not going to be that bad. I don't know that that's at all the case. And I don't know how we can assess that in any meaningful way.
Alicia, what do you make of this case and the apparent dilemma that is facing the justices now as they try to figure out the way that they should rule?
So I think there's one issue is how this case, and actually the case that's being heard today, which is similar but doesn't actually directly or explicitly involve Section 230, but rather involves whether these plaintiffs can even sue these platforms for essentially aiding and abetting the terrorists, because it's not clear, there really isn't any direct line between what the platforms did, whether the terrorists actually saw any of the videos, and whether that actually inspired them to go out and commit the terrorist acts. So that's a separate question that's actually at issue in the oral arguments, the Twitter v. Tamana, that are being heard on Wednesday. So it's a little strange that they're hearing the arguments after they consider the Gonzalez v. Google case, which takes aim directly at this Section 230, which Congress designed back in the days of AOL in the 1990s. And I shouldn't say that Congress designed this. This was actually thrown in. It's more of an afterthought to deal with the issues that were percolating in the courts at the time, roommates and other cases in which companies were being sued for content on their sites because they were exercising editorial control. In some cases, they were being sued essentially as publishers and being held liable for that content. So Congress came in, really championed by a few members, Chris Cox, namely, to clean up the mess that is happening in the lower courts and to provide protection for these companies. Again, we didn't really have the Google that we did nowadays. It was more like sites like Craigslist, which people were just posting. The content wasn't so much curated. It wasn't controlled as much by algorithms. But the intent was basically to protect the platforms from being held liable for content on their sites, which they didn't develop, was created by users. And there's really no question whether someone, like, say, if I posted something on Yelp or if I posted something on Facebook, defamatory, I could be sued. But to go back, the intent of Section 230 was to protect these platforms from also being sued, which really allowed the internet to grow into what it is today. And so stepping back, if we were to all of a sudden, I think that what Justice Kagan is getting at, if all of a sudden we were to read Section 230 very narrowly, not to cover the search search engine recommendations, or in the case YouTube recommendations, it would really kind of defeat the purpose of Section 230. The opposite argument is, well, this law is actually kind of not clear in many respects. And courts, in some cases, have interpreted it much too broadly. And that's an argument Justice Thomas has made in previous opinions. In this case, it was kind of interesting listening to the oral arguments. That wasn't actually something that he was raised here. He seemed to be a lot more sympathetic to the tech companies.
To underline a couple of the points that Alicia made, one is that, again, the case yesterday was Gonzalez v. Google, and it involves this woman who was killed in an ISIS terrorist attack. Google says in its brief that there's no allegation that any Paris attacker saw any ISIS video or that YouTube played any role in bringing about the Paris attack. And so today there is another case being heard, and this one involving Twitter. And the question there is whether the laws against aiding and abetting terrorism even apply to a generic, widely available service that is not directly tied in any real substantial way to any specific terrorist act. So it does seem to me that perhaps one way out of these two cases is to rule that no, Twitter is not responsible for what happens in an ISIS attack, that there's no direct connection to Twitter, which would also apply to the Google case. To underline the point about Section 230, my understanding of the development of that piece of law was that in the 1990s, what happened was there was some cases where if an internet platform did any sort of removing of inappropriate or egregious content, did any sort of that kind of editing at all, it would be held as a publisher of everything on its website. And so it would be liable for any sort of defamation or what have you that it did not take down, which gave the publishers, internet platforms, a choice. They could do no editing and let anything bad that they didn't like run wild on their website, or they could do some editing and take responsibility for everything. And that was not a particularly good choice. So that is why Congress passed Section 230. And the provision at law in the case yesterday says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. And you can hear just in some of the terms, Kim, in that law that this was passed in 1996. It doesn't mention anything about social media because social media had not really been invented yet. The word blog had not been invented yet. So you heard some of the justices, particularly Justice Kagan, struggling with the idea of we're a court and we're being asked to apply this law that is kind of unclear and uses outdated terms to the modern internet, which functions in a very different way than it did in 1996.
Yeah, and to listen to the tech companies, they would make the argument that absent Section 230, you wouldn't even have all of these things that we have today, all the search engines, all the different online platforms that we do. In fact, the tech industry has taken to calling Section 230 the Magna Carta of the internet. And it's why you saw so many giant players out there in tech world file friends of the court briefs on behalf of YouTube in this case, Etsy, Glassdoor, Microsoft, Pinterest, Reddit. And of course, what's happened as the internet has grown, we're no longer talking about websites where people are simply posting things. I mean, think about how rudimentary everything was back in the 1990s we're talking about. I mean, these were really standalone websites where someone might have the ability to post something on there, but it was very, very small world. As the internet has grown, obviously, we now have things like these search engines, YouTube. The additional burden has now fallen on these tech companies to use these kind of algorithms to sort content and get people to where they need to go. For instance, one of the things that came out in the court, which is interesting, is YouTube gets something like 720,000 hours of content uploaded in a day. How do you sort that out and let people get to what they want? So of course, they've adopted these algorithms. And that's one of the aspects of this case, which is that the plaintiffs are claiming because they are now taking an active interest and moving people and highlighting, or to use the plaintiff's terms, they're auto-generating content, they're amplifying content, they're recommending content. Their argument is that this is now crossed into the line of actually engaging in somehow and giving people content in a way that makes them a publisher in essence and makes them therefore liable for what is online. Now, that's a big leap. It's a completely separate question, as Alicia was talking about whether or not anyone can prove the people in this case actually watched a video and that was what inspired them to do it. But it's that bigger question about the functionality of these things and the different tools that they use, whether that house somehow makes it so that Section 230 should essentially not apply. And that is a big question for the court. And I think that's what Elena Kagan was getting to and Kavanaugh was getting to, which is that to somehow now rule that it doesn't would be an enormous shift, okay? It really would be a big deal. And as Kagan said, you don't necessarily have to buy the argument that the sky is falling if they ruled that way, but no one can deny that that would be a kind of significant decision by the court that would have widespread implications for everything that we see online these days. And I think that's why you see the court reluctant to deal with it. And as Kavanaugh said, maybe this is something Congress should deal with.